everyone, welcome back. This week we're going to continue on with Chapter 6, and we're going to be talking about the last part of search and seizure, which is exceptions to search warrants, okay? So it's a little bit of a longer lecture, but it's going to go through all of the different exceptions to getting a warrant, which is still part of Chapter 6. So last week we did Chapter 6 where we talked about the warrant and we talked about execution of the warrant. This week we're moving on to, okay, well, what if you don't get a warrant or properly execute it? What are possible exceptions? So I'm going to share my PowerPoint and we're going to talk about those different provisions. Okay, so like I said, we're moving on to warrantless searches. So we have talked a lot about warrants. Now we're going to talk about warrantless searches. So if you flash back to the search and seizure analysis, we keep going over this over and over. We said the first step is deciding, is it a search under a protected search under the Fourth Amendment? And then this last week in Chapter 6, we talked about, okay, if it is a search, is it reasonable? And that's the part of the analysis we're still on. Now, remember, we said always, always, always get a warrant. Warrants always protect the police officers because it's another set of eyes. It's a judge looking at the information and making sure that it is proper. So always, always get a warrant if you possibly can. And then always make sure you're executing that warrant in a proper manner. That's going to be de facto reasonable. So it's going to always protect the police. But are there some circumstances where police could still search even though they don't get a warrant? Can it still be considered reasonable? And that's where we talked about warrant and execution is always reasonable, but there may be valid exceptions to warrants. And that's what we're going to talk about this week. So think about this. A police officer has unlawfully arrested a suspect and is leading him away. While walking, the suspect attempts to reach for something in his pocket. What should the police officer be thinking about what he or she sees when they see this behavior? So you're a police officer, you're walking down, you see them kind of reaching for their pocket. What's your first instinct? Well, your first instinct would probably be that the person is doing something suspicious. So if that's true, what can a police officer lawfully do if they don't have a search warrant? And that's always the question. So you see something, it's suspicious, but you don't have a warrant. Is there anything you can lawfully do? And this came up in the case of U.S. versus Rabinowitz. And in U.S. versus Rabinowitz, the Supreme Court said, we will allow certain limited searches when an arrest is being made as long as it's deemed reasonable, okay? So limited searches during an arrest may be acceptable and reasonable. This created what was called the search incident to arrest exception. So under this decision, when they arrest you, police are allowed to conduct a brief search, full search, pockets, stuff like that, on your body to make sure you don't have anything dangerous. So that became known as the search incident to an arrest exception, which is a very often used exception. So whenever police go to arrest somebody, they're always going to search you when they handcuff you and put you in the car. Now, what about an arrest for a non-serious offense? What if they're arresting you for just like a traffic ticket? Now, that's always the question. Can they still do a search incident to an arrest? And what the Supreme Court said is it doesn't matter. The search itself isn't the issue. The issue is was the person actually taken into custody? So if you're just given a violation and let go, then you cannot use search incident to an arrest. But if you're taken into custody, it's an actual arrest, and they're actually taking you into custody. It doesn't matter what it's for, even if it's a minor traffic offense. If they're actually taking you into custody, then search incident to an arrest does apply. Okay, so then they came up with basically this Robinson rule. Officers are always permitted to search anyone taken into custody. So if we're taking you into custody, we're actually putting you in the police car, taking you into jail, they are allowed to search incident to an arrest. And the idea is that you always pose a danger to those police when you're being put into the back of the police car. But we're not automatically going to allow that if you're just given a ticket or anything like that. So it has to actually be an arrest where you're taking the person into custody. Now, what if the search occurs after the arrest is complete? So I go to arrest you, I handcuff you, I put you in the back of the police car, and then later I decide I'm going to search you. The Supreme Court said, no, you can't do that. The search has to be contemporaneous with the arrest. The whole purpose of the search incident to an arrest is the idea to make sure you're safe to arrest. So no, you have to have the search be contemporaneous with the actual arrest. Now, are there any exceptions to this possibility? Can you possibly ever search later? And this came up in U.S. versus Edwards. And the Supreme Court said, yes, there are some circumstances where you could possibly search later. And the idea was if you're in a dangerous situation and you just need to get people arrested and put into custody quickly to protect their safety, to protect the police officer's safety, we're going to allow it sometimes, but you're going to have to look at the facts. So was the search, the immediate search impossible? Was it too hard to do right at that time? Was the exigency or emergency still existing later at the time when the search is conducted? Okay, so if there's a situation, then they have to search, just get you in custody and get you away, then they could search later. So one example of this is there was once like a traffic accident, and I think it was a white driver driving in a predominantly Black neighborhood, speeding, recklessly driving, and hit a child and killed a Black child. And the people in the neighborhood were really, really upset, and they went and were starting to attack the driver. So the police had to get in there, arrest that person, get them away for their own safety, and then they could conduct the search at a later time. So that's what we would be a possible exception to that contemporaneous requirement. So if we're allowed to search incident to an arrest, then the next question we have to ask is how far can the search extend? So how deep or intense of a search are the police allowed to use? And this came up in Chamel versus California. And in Chamel versus California, the police wanted to search certain areas. How much of the house could they actually search? So they were arresting the person in one part of the house. How far is the search permitted? And the Supreme Court basically created a test for how far that search could go. And it said searches are invalid if they go beyond what the person's immediate control is. So if I'm arresting you in the kitchen, that's the area immediately in the kitchen. That has been referred to a lot of times as what we call the grabbable area. So the idea is when I go to arrest you, any area that you could break away and grab something very quickly that could hurt yourself, hurt other people, destroy evidence, we're going to allow police to search there also. So if you think of it this way, Rabinowitz allowed them to search the person incident to an arrest, and then Chamel allows that grabbable area. You can search anywhere in that grabbable area. That generally means they can search anywhere within the immediate area or room where the person was arrested. So you can search in drawers, you can search in cupboards, you can search anywhere that a person could access very quickly if they happen to escape control of the police for just a few seconds. So that's, a pretty broad general area where police can search when they are first arrested. So when executing a valid warrant for assault in Dee's home, officers searches and seizes a handgun in the person's pocket. Alarmed that her life could be in danger, the officer makes Dee lie face down, handcuffs them, and then quickly walks through the adjoining rooms. While in the kitchen, she notices a pile of semi-automatic weapons on the tables and seizes them also. So we know you, Rabinowitz person, Chamel, grabbable area. So now the question is, was it permissible for this officer to walk around to different adjoining rooms? So the Supreme Court had to make that determination. And that came up in Maryland versus Bowie. And in Maryland versus Bowie, there was a robbery at a convenience store. And the convenience store operator said that the suspect was that there was two people. The one was wearing a red jogging suit and that they were armed. So they narrow it down and they figure out that it's Bowie. So they go to Bowie's house to arrest him. As they walk into the kitchen to arrest him, Bowie walks up from the basement. So they handcuff Bowie and then they proceed to walk down into the basement. So think about the facts that I told you. What gave them reason to believe that they could walk down? Well, number one, weapon. Number two, they were also worried that there was another person there, right? So in Maryland versus Bowie, the Supreme Court extended that search incident to an arrest to include what's called a protective sweep. So now under Bowie, not only can the police search the person and the grabbable area, they can walk around adjoining rooms. But the catch is, for a protective sweep, police are only allowed to look for people or weapons, okay? And they can only look in those places where, well, I take it back, I'm sorry. They can only walk in the adjoining rooms to look for people. If they're looking for people and they happen to see weapons or illegal things, that's plain view. It's a search-related plain view, and you're going to be allowed to take those things. In Maryland versus Bowie, when they went downstairs, they saw a red running suit hanging. So they were allowed to look for people because they were looking for the second robber. And then they just happened to see a piece of evidence in plain view, so they could seize that. But keep in mind, protective sweep is only for people. So that means you can only search in areas that you're looking that a person could be. So no looking in drawers or cabinets or anything like that where a person could not fit. You're only allowed to look for people. Okay, so does this exception allow police to seize cell phones and search the data on the cell phone? So when they search you incident to an arrest, and they look at your body under Rabinowitz and they find a cell phone, does it permit the police to seize that cell phone and also to actually look through the cell phone at the data that's contained on that cell phone? And the Supreme Court said no. So they can seize the cell phone, but they cannot actually access the data without a warrant. So with Rabinowitz or Shamel or something like that, they can seize it, they can take it into custody to keep it from being destroyed, but they just have to hold on to it until they actually have a search warrant. They are not allowed to actually access the data on that phone. Now, what if it is a search incident to an arrest and it's determined that the arrest itself was illegal? So later they find out this was an illegal arrest. This was a bad arrest. What happens to the evidence that was obtained during the bad arrest? Because it was search incident to an arrest, but a bad arrest. The Supreme Court said it's thrown out. In order for a search incident to an arrest to apply, it has to be a legal arrest. Okay, so we're only going to allow search incident to an arrest to apply if in fact it is a legal arrest. Now let's take it the next step further. What if you're being pulled over and arrested out of your vehicle? So you're driving down the road, you get pulled over and they want to arrest you and your car is still sitting there. Can you use search incident to an arrest to search inside of the car? So when you get pulled over, you're taken out of the car. So now the arrest is made outside of the car. Can they still search the car to find anything? Is that part of the grabbable area? Is that part of search incident to an arrest? And the Supreme Court said yes. Police may search the passenger compartment, search incident to arrest, if they have reason to believe that there is contraband or evidence within that car. So if I pull you over for driving under the influence of drugs, and I arrest you outside your car, and I believe you still have controlled substances in your car, and I have reason to believe, I have boxes of probable cause to stack up for that, then I am permitted to make that search of your car. So then the next question is, how far does that search extend? So I'm searching a person out their car after I arrest them outside the car. Am I allowed to look in locked trunks or locked glove boxes or things like that? And the Supreme Court said, no, it doesn't go that far. So we now know search incident to an arrest, you're only allowed to search the compartment where the passengers would be in. Okay, because that would be grabbable area. That would be an area if somebody jive back in the car, they could grab something. But searching a trunk would not be a grabbable area. So that would not be permitted. So search incident to an arrest for a car only includes the passenger compartment. Okay. Now, what if the vehicle stop was just a pretext stop? So some of you may know you're not allowed to have things hanging from your rear view mirror. So when police pull you over, they're not usually generally trying to give you a ticket for that, but you're giving them a reason to pull you over so that they can check to make sure you're not drunk driving or you have a license or you're not a felon. Those are what we call pretext stops. They have a valid reason to stop you, but it's really on the pretext that they want to search or find something else worse than what they're stopping you for. So broken headlights, one headlight, something hanging from your rear view mirror, stickers on your back window, things like that could be what we call a pretextual stop. So what if the arrest is made for a pretextual stop? Do we still have the ability to search incident to an arrest and to search the passenger compartment of the car? And the Supreme Court said yes, as long as it's a valid stop and a valid arrest. It doesn't matter. You still are allowed to do that as long as you have that arrest. So again, as long as they're taking you into custody, not only can they search the person, they can search the vehicle if they have reason to believe that the vehicle is containing evidence. So remember, for search incident to an arrest, you still need basically probable cause, either probable cause to arrest or probable cause that the car has contraband. It's just that you don't have a warrant, okay? So what I want you to do is I want you to stop this video and read through this and determine if search incident to an arrest exception would apply to any of this evidence. So take what we just learned and try to apply it, okay? So an officer arrives at home for a domestic violence call. Entering the home, she sees the suspect hide a gun in his pant waistband. So in his pant waistband, officers remove the gun and search the suspect's other pockets where she finds crack cocaine. The officer then searches the entire room, including all the cabinets and drawers where the arrest occurred. She found additional drug paraphernalia. She then walks around the rest of the home where she locates another gun in the drawer of the nightstand next to the couple's bed. Will the prosecutor be able to use the following evidence at trial? So the gun in the waist pants. Okay, so arrives to domestic violence, enters the home, sees the suspect hide the gun in his pants. Would that be permitted? Okay, so if I am making an arrest for domestic violence, can I search their waistband for guns? Yes. Number one, it's plain view. You saw him put it there. And number two, it's search incident to an unlawful arrest. So if you're going to arrest him, you can search his pants and remove that gun. Okay. The crack cocaine from his pocket. So they then search the pocket. So the gun is plain view. Now they're going into the pockets. So they have a lawful arrest for domestic violence. They now have a gun, unlawful possession of a gun. So they're making a lawful arrest. Are they permitted to go into the person's pockets? Absolutely. That's Rabinowitz. Okay. Now, drug paraphernalia in the room where the arrest occurred. So we learned about Shamel and grabbable area. Can we look in drawers and small places in the area immediately under the defendant's control when we are making the arrest? And the answer is yes. So that would be okay. It doesn't matter that it was, in a smaller area or anything like that, as long as it's in the area of immediate control. Now she walks around the rest of the home, right? That's a protective sweep. What are you looking for in a protective sweep? You're looking for people. So are people going to be in the drawer of a nightstand next to the couple's bed? No. So that would be an illegal search. So that would be excluded under the exclusionary rule. So hopefully you got that all right. Okay. Now, Officer Bob observes a car driving the wrong way on a one-way road. He tries to stop the car, but the driver fled, resulting in a high-speed chase and crash. Concerned the driver might ignite from a gas leak. So the car might ignite from a gas leak. The officer pulls an unconscious man from the car. While pulling the man to safety, he notices narcotics and a large sum of money on the front seat. Can we use the drugs and money against him at trial, or should it be excluded? So this came up in Kerr versus California. And this is another exception that the Supreme Court made. It's called the emergency or exigent circumstance exception. And what the Supreme Court said, if police have probable cause that there is an emergency or what they call exigent circumstances, like emergency circumstances. So emergency and exigent circumstances are the same thing, emergency and exigencies. So don't get confused, those words mean the same thing. If police can point to an emergency or exigent circumstance, police may be able to conduct a search without a warrant. But the police are going to have to show that there was in fact probable cause and that there was, in fact, an emergency or exigent circumstances. They're going to have to convince the judge after the fact that those things existed. Okay, so what would qualify as an emergency or exigent circumstance? Well, anytime there's a possibility that the officers could be injured, so you need to conduct the search immediately to protect the safety of the officers. If there's a chance the person could escape from justice and they could be a danger or injure other people, if there's any evidence that they could destroy evidence. Those are all going to fall under emergency or exigent circumstances. So the idea is that if the police have probable cause, but they don't conduct a search right there, one of these things is going to happen. So if they wait, go get a warrant and come back, one of these four things is going to have happened. And that's an emergency or exigent circumstance. We're not going to allow we will allow police to conduct a search without a warrant in these situations. So police are attempting to arrest George and they have probable cause. George runs from the police. He runs down the street and into his home. Okay, so can the police chase him into his home? So they go to arrest him. They see George committing a felony. They go to arrest him. He happens to break away and run away from the police and he runs into his home. We know homes are extremely protected under the Fourth Amendment, and you almost always have to have a warrant to search inside somebody's home. But is this an exigent circumstance? Is this an emergency? And the court said, yes, this is what we call hot pursuit. This is the injury to others, injury to the police. Person could escape, could continue to destroy evidence. So those are going to fall under exigent circumstances. So the exigent circumstance is that the police were in hot pursuit after the person. So yes, that search is going to be okay. You're going to be able to enter the home to arrest him. And then if you're in there and you see anything, you can then search according to the search incident to the rule, incidental rules. Okay. Now, there is this concept called evanescent evidence. So what do you think evanescent evidence is, if I asked you? Well, evanescent evidence is evidence that may be quickly lost or destroyed. So there's certain evidence that if it's not gathered or searched and seized immediately, then something's going to happen to it and it's not going to have any value. So the question is, if the evidence could disappear, not that the defendant necessarily is destroying it always, sometimes, but it by itself, the evidence could disappear. Can we search and seize that evidence quickly? So if that, can officers search for evanescent evidence without a warrant under the exigent circumstances exception? Because we know the evidence is going to disappear. And the Supreme Court said, yes, we are going to allow it, but only if you meet these certain requirements, okay? So only if you can prove there's absolutely no time to get a warrant, you were not able to get a warrant because of the facts and circumstances surrounding the arrest and search. There's a clear indication that the search will produce evidence. So you can't use it for just like a witch hunt to just search for things. You have to have reason to believe the evidence does exist there at the time. And the search could be done in a reasonable manner. It cannot be shocking to the court, the procedures that are used for the search, okay? So we will allow this kind of evanescent evidence if you can meet each of these three requirements. So then there was a case, Mississippi versus McNeely, where McNeely was pulled over for DWI, and the police take McNeely to the hospital and say, you have to draw his blood and test it right away, but we don't have a warrant. But it's okay because it's evanescent evidence. The alcohol in the blood is going to disappear quickly if we don't get the evidence, so we don't need a warrant. And the Supreme Court said, no, we're not really going to allow that. Disappearing alcohol from the bloodstream is not always exigent circumstances. So in general, if you want to blood test somebody for DWI, in most circumstances, you're going to need a warrant. They're not going to classify disappearing alcohol from the blood as a form of evanescent evidence, okay? Now, police arrive at a scene and see a woman with a smudge of blood on her hands. So they know there's a violent crime. They get there and they see blood on her hands. As they are walking to her, she's desperately trying to wipe it off. So they run to her, grab her hands, use Q-tips to try to swab the blood and search that blood. So is that permissible? Would that qualify as evanescent evidence? And the court said yes. As long as you can prove that it was a true emergency, that there was an immediacy to it, or the evidence would be completely destroyed, then yes, you can use it for that type of thing. Now, can police search your car without a warrant if they have probable cause to believe it contains evidence or contraband? So we already know search incident to an arrest, they can search the passenger compartment. But what if they're not arresting you? What if they don't have probable cause yet to arrest? They believe that your car may contain contraband or evidence, but they don't have enough evidence yet to an arrest. One crime, one person, right? So if you don't have probable cause to arrest, can we still search a car? Is this a possibility? And this has become known as what we call the automobile exception to the warrant requirement. What the Supreme Court has said is if police have probable cause to believe that your car contains contraband or evidence of a crime, we will allow the police to search your automobile, okay? But you have to prove that there is probable cause to believe the car contained alcohol. So the Carroll versus US case was a case during Prohibition where the police suspected that the car was transporting alcohol. And so they pulled it over and they ripped up the seats and they found alcohol. And as the court said, as long as they can point to probable cause, as long as they can stack up all their boxes to prove that probable cause exists, they can search even if they don't have a warrant. And this makes sense if you think about it. If you pull over a car and think that there's contraband in it, you can't say to the driver, just stay here, wait right here, we're going to go get a warrant and come back, leave and come back with a warrant, because the car is going to be gone. Cars move quickly, right? So we are going to allow police to search these cars because of that, but only if the police can demonstrate that probable cause existed for them to do the search in the first place. Now, remember, they're going to have to prove this after the fact because they're going to pull over, they're going to search the car. Then later, the defendant's going to challenge it in court and say, no, there was no probable cause. So the police officers are going to have to justify the search, build up their blocks of probable cause to the judge after the fact. And remember, if they're wrong, then that evidence will be excluded. The automobile exception would not apply. So we said search incident to an arrest. We could search the grabbable area, which was the passenger compartment of the car. If it's if it's automobile exception, is it the same area? Are we only allowed to search the passenger compartment, or are we allowed to search more? And the Supreme Court said, when it is an automobile exception, you're going to be able to search everything in the car, the entire vehicle and all contents in the car. So if I can show that probable cause exists to search, not only can I search that passenger compartment like we did search incident to an arrest, but now I can go in the trunk. Now I can go in the bags and the suitcases and anything that's in the car, the glove box. I can search anywhere in the entire car as long as I had probable cause, okay? So I can look anywhere. So it's much bigger than search incident to an arrest. Now, what if there's a passenger in the car? Am I also allowed to search that passenger's belongings? So I have a passenger, a woman has a purse. Am I also allowed to search that passenger's purse because it was in the car? And the Supreme Court said, yes, as long as there's probable cause that there's contraband, then you can even search passenger belongings. So passenger bags, purses, backpacks, luggage, anything like that. As long as you have probable cause and you meet the requirements for automobile exception, then the police can also search those passengers' belongings. Okay. Now, what about the search of a mobile home? So, you know, some mobile homes have wheels and people live in like RVs or mobile homes, or watercraft. Some people live on boat houses or watercraft, like your boats. Do those also fall under automobile exception? Okay, or are those more home? So do we classify them as automobile exception, or do we give them the more protection that exists under the Fourth Amendment for homes? And the Supreme Court said it depends. We have to look at all of the facts and circumstances surrounding the vehicle. Is the vehicle likely to still be used for transportation? Is it movable? Can it move? If it can still move, then it's more likely to be classified as an automobile. An automobile exception would apply. If it doesn't really have the ability to be used for transportation, then it's more likely to be home, okay? And what the test is it more mobile than home? So if it's very mobile and it can still move and be used as transportation, you can use the automobile exception to search that as long as the officer has probable cause. But if it's not really movable, then it's going to be more home, and you're going to have a warrant. You're going to have to follow the requirements for a search warrant as it protects a home. It's expressly protected in the Constitution. So it's going to be much harder for police to search it in those circumstances. So I found this one diagram, and I think it makes a lot of sense. It kind of explains it. So how do you determine if it's used for transportation function? Is it mobile or stationary? So this car has no wheels and it's on blocks, where this one does. So this one's going to be more stationary. This is more mobile. Whether it's licensed, do they have plates on it and things like that? If it's like an RV, is it actually connected to utilities? So it's not like you could just jump in and drive it away because it has some utilities connected to it. Whether it's convenient to road access, do they have the ability to jump in it and leave right away with road access? So the court's going to look at all of these factors and make a determination. Is it more mobile than home? If it's more mobile than home, automobile exception will apply. If it's not mobile, home requirement for a warrant is going to apply, which is going to be much harder for police to search. Okay. Now, this was a more recent case. It just came up not that many years ago. So there was this unique motorcycle that kept evading police. Every time they tried to pull it over for violating the traffic laws, it would speed away and it always got away. So after some investigation, they found out where they believed the driver lived. So they had the license plate, but they couldn't always tell if that's the owner was the driver of the automobile, of the motorcycle. So they go to the address where the motorcycle is registered, and the police see this motorcycle covered with a tarp. So they can't see whether it's the same motorcycle or not. They believe it might be, but they don't know for sure. So the officer walks onto the person's driveway because the motorcycle is on the driveway close to the house. The officer walks on the driveway and picks up the tarp to confirm that it is the unique motorcycle that they are looking for, which they know is also stolen. When they realize it's the same motorcycle, he sits in his police car and he waits for the suspect to return. And then as soon as the suspect returns, they arrest the suspect. He denies anything. And he then eventually confesses that he bought the motorcycle knowing it was in fact stolen. And then he is arrested for receipt of stolen property. So the question is, was that a valid search? So it is a search. So if we go through the analysis, it is a search. It's an effect, which, you know, person's house's paper is a fact. So you would need a warrant. So then we have and he did conduct an actual search because he lifted up the tarp. So the question is there an exception to the warrant? Because the officer did not have a warrant at this time. Was there a valid exception to the warrant? The officer claimed automobile exception. It was more mobile than home. It could be moved. So they should have been able to go onto the property and search to see if it was the motorcycle. It went all the way to Supreme Court because the defendant argued, no, nobody was home. Nobody was using it. It wasn't mobile at the time. And you had to actually walk onto my property, my curtilage, which is home, which is expressly protected by the Constitution. And the automobile exception did not apply to that situation. And the Supreme Court agreed. So the automobile exception does not permit police to walk onto private property to search vehicles that are parked on private property. So we're not going to be able to use it. And we can't use emergency or exigent circumstances because there was nobody there. They weren't trying to destroy the property at the time. So what could have they done? They could have sat there. They could have made sure nobody came home, nobody touched it or heard it in any way. If they did, then emergency circumstances might have kicked in. But in this case, it did not. Now, so when we think about and compare search incident to an arrest to automobile exception, there's different standards. So if we are searching incident to an arrest, we pull somebody over, we're going to arrest them and we want to search their vehicle. Remember, we can only search the passenger compartment. So it's a much smaller search. But if I can prove probable cause that there's some contraband in the car, then the automobile exception kicks in. Now I can search the passenger compartment, the glove box, the suitcases, the bags, and the trunk. So when possible, police want to fall under the automobile exception because it gives them more ability to search a larger area. But sometimes you can't. Sometimes the only exception you have is search incident to an arrest, and then you are limited only to the passenger compartment. So make sure you keep those two things straight in your head. So you are traveling from Columbia to New York. The police stop you after you pass through customs. They ask you if they can search you and you say yes. And later it was determined that they did not actually have probable cause to search. Is it still a valid search? And the answer is yes, because this is what we call consent. So anytime an individual gives the police permission to search, that is a valid search. This is the one exception to the warrant where they don't even need probable cause. No probable cause is needed. It's not necessary. You don't have to have probable cause. As long as the person consents, then you are okay to search, okay? Now, sometimes they have probable cause and they could fall under another exception, but they just ask permission anyway, because it kind of makes it neater. They don't have to fight it in court necessarily then, because the individual has already consented. So sometimes they could ask you and you could say, no, I don't consent, and they could search anyway, and then they would just have to rely on one of the exceptions. But if the person says yes, then they're okay to search. But what about this? Officer Smith pulls over Jacob for suspicion of drug smuggling. After he approaches the car, he asks Jacob if he can search the car. Then when Jacob hesitates, Officer Smith tells Jacob that he will arrest him if he does not consent. Would this be considered a valid consent? And the courts have said no. In order for it to be a valid consent, it has to be voluntary. Police don't necessarily have to tell you that you can refuse, but they can't put you under duress or threaten you in any way to get you to consent. So if they try to do that, you just have to say, no, I don't consent. Be polite, be strong, but just say, I'm sorry, officers, I don't consent to any searches. And if you don't consent, they're not allowed to search. They cannot force you. If it's not a voluntary consent, it's not an exception to the warrant. They could not search. So what are courts going to look at to determine if it is in fact voluntary? They're going to look at lots of factors. Again, we talk about this throughout the whole semester. Total circumstances. So how much does this person actually know their rights and their ability to refuse consent? Like, are they like a hardened criminal that should have known this? Or are they an attorney like me that should have known it? Are they sufficient age and maturity to make that decision? Can they even consent based on their age? Do they have the intellectual capacity, the intelligence to understand what it means to consent? Have they been past experience with the CJ system and they've been arrested before, so they should know? How much are they cooperating with the officers? How long were they detained and how much were they questioned before they finally consented? And did the police use any sort of coercive behavior to force the person to consent? So courts are going to look at all of these factors to determine if it is in fact a voluntary consent. So what would make it involuntary? If the person's drunk, if they're mentally incapacitated, if they're too young, if they ask for an attorney, if they're coerced, if they're under duress, if the police make false promises or lie to them in any way, then that's not going to be a valid consent. So police can destroy consent by putting the person under duress, but if the person is visibly intoxicated, drunk, or under the influence of drugs, clearly has mental incapacitation, mental illness, or intellectual disabilities, or if they're too young or they want an attorney, that will invalidate any consent. So if you refuse to consent, does it automatically give police probable cause? So police are suspicious, but they don't have probable cause. They ask you to search and you say no. Well, that's suspicious in itself. Can that be a block in establishing probable cause? And the Supreme Court said, no, you cannot use the actual refusal to consent. You have a constitutional right to refuse consent, and to use it against you if you assert that right is bad, and you can't do it. And just as an aside, courts almost always find consents voluntary. It is very, very hard to find too many cases where the court said, no, it wasn't valid consent. Almost always they side with the police and say it was in fact voluntary, okay? So once you consent, the next question is, how far is the search permitted then? Can they just search anything they want as soon as you consent? And the courts have set standards. No, consent doesn't just mean anything, anywhere they want. It's only as far as the person consents. So if I say, yes, you can search my trunk, then the search is limited to the trunk. If it's not specified, it's just what's deemed reasonable based on the consent. So if they say, can we search? And you say yes, and it's a vehicle pullover, that doesn't mean my house and my shed and all my other cars. It's what would be reasonable under the circumstances, what the court deems that consent extended to. So you have to be careful a person consents that you don't extend the search beyond the consent area. Can you change your mind? Can you withdraw your consent? And the courts have said, well, some of the state courts have said yes. Supreme Court has not decided this issue, but other courts have said yes, as long as you do some unequivocal act or statement that withdraws your consent. So you can't be wishy-washy, be like, oh, I'm not sure, I want you to search, oh, I don't know, should you stop? You have to say, no, I withdraw my consent, stop searching. I no longer give you consent to search. So it has to be unequivocal, has to be forceful, an act, maybe you step in front and say no more, or a statement. You have to withdraw your consent unequivocally to the police, and then you no longer consent. So just some other quick consent issues. Can someone else consent to a search of your property? Who has the authority to consent to a search of your property? And these are what we would call third-party consent. So who is allowed to give the police consent to search that party? And it often depends on who has actual authority or apparent authority. And generally the law says only people with actual authority, so the actual owners, the people that have possessory interest in that item, would have the ability to consent. But remember Illinois versus Rodriguez, that was the woman that went to the police and said that her boyfriend beat her up. So the police go over, she opens the door with the key, the man's passed out on the couch, and they find drugs, right? And he says, wait, she doesn't have authority to let you in. She doesn't live here anymore. And they said, well, she has a key. And they said, too bad, she doesn't live here. So what type of authority was in this case? It was apparent authority. It wasn't actual authority, but the court allowed it because it was good faith, okay? But remember, in New York, there is no good faith. You actually have to have authority in New York before you can search. So can landlords consent for their tenants? No, they don't have actual authority. The tenant has possessory interest and the landlord can't consent. Can a hotel manager consent for guests? Same answer, no, they cannot. Can a college official consent to search a student's dorm? Now, the college official may be able to go in based on the agreement you sign when you're in a dorm, but can they give police consent? And the courts have said no, but this is just Fifth Circuit. It's never gone to the Supreme Court. What if you share an apartment with another who consents when you're not home? Can they search? Yes, but only areas that they have authority to consent. So areas of common authority. What if everybody's home, some say yes, some say no? Can they still search? Court said no. If they're all there and anybody disagrees, can't search. But what if the one that says no leaves later and the police show up when the others who consented are the only ones there? And the court said yes. I know it's crazy, but the court said yes. That's okay if the non-consenting person is no longer there. Now, in New York, what do you think? So police pull over a vehicle for speeding in an area with lots of illegal hunting. The police don't have direct suspicion the person was illegally hunting, but ask the driver to search the car. The driver agrees. Police find a dead body in the trunk. Is this search permissible? So they don't have probable cause. They don't even really have a reason to ask for consent. So should the police have asked? And in New York, the court said, no, we don't want police even asking if it's just a traffic infraction. We don't want to give police that discretion or that power to possibly coerce or force people into consenting. So if it's just a traffic infraction, unless there's some reason to believe there's evidence in the car, police are not even allowed to ask for consent to search. So what are some of the overriding rules? Wives and husbands can consent to their partner's property being searched. Parents can consent to their children's property being searched, but children cannot consent to have their parents' property searched. So those are some additional rules that hint may come up later in the class. So just as a summary, these are all the exceptions we talked about. So search incident to arrest is Rabinowitz, the body, grabbable area, Shamel, buoy, protective sweep. We talked about consent, and it must be voluntary, and they have the ability to give consent, the authority. We talked about automobile exception. If you have probable cause, you can search the whole car. We talked about emergency exigent circumstances, and hot pursuit was part of that. And then don't forget, we said if something's in plain view, it's not even a search. So sometimes they list it under not a search. Some people use plain view exception, okay? So what I want you to do is read through each scenario and decide which exception could apply and whether you think it would be valid, okay? So I'm going to click through them. So stop the video after the question, analyze it, and then start it when you're ready. See if you got the answer right. So this is the first one. Oops, sorry, I went too fast. I'll go slower now. What about this one? So hopefully you got that right. What about this one? Hopefully you got that right. There you go. There you go. Couple more. Okay, so if you have any questions about those, let me know. I think I also have a practice assessment that you can redo them later if you want to try. So now we're going to take everything that we learned and we're going to put it together in the search and seizure analysis. So everything we learned so far about search and seizure. So remember, we're going to use the IRAC method. So when you write your answers, you're going to have issue, rule, analysis, conclusion. So I'll give you a problem. So police received a call from people fighting at 450 West Street, apartment 3C, and arrive within 30 seconds, enter the building and climb the stairs. They notice apartment 3C's doors cracked open and hear Spanish, but they cannot see anything. They call out police and push open the door. They see Diaz 12 feet away with a gun in his hand pointed down. He drops the gun. Another man, Perez, also has a gun, throws it out the window. Officers see 4 bags of cocaine, triple beam scale, and a granulator on the table. The gun thrown out the window is later recovered. You are the defense attorney. How would you argue this case? So issue. Was it a reasonable and valid search, or should the drugs and evidence be excluded? So was this a valid search? So now you can do the actual analysis to determine if the search was proper. So we always start out first with our conclusion. The police conduct was an illegal search when they entered the home illegally, and all evidence should be excluded at trial as fruit of the point of the illegal search. Okay, and then I just restated some of the facts. And then I list my rules. So remember, rules section is just sort of like your citations. What are the things you're going to rely on? So it's Fourth Amendment, search and seizure. So we're going to list that. Then we're going to look back through our notes and we're going to identify any cases that apply to this. So the first one is, was there governmental action? Fourth Amendment, Harris plain view, because we're going to use plain view in this scenario. Kerr, we're going to use emergency exigent circumstances. And Bingham Street versus Stewart, unless the emergency is real, then you have to believe someone could be injured or evidence destroyed. Okay, so we're just listing them under the rule. We're just listing what could be used. Then we're going to the analysis. This is where we take out our flow chart and we start at the top. And we're going to work through each question. We're going to answer each question and explain and use court cases to justify each part of the answer. Okay, so we start at the top. When you read the scenario, was there governmental action? If there was governmental action, were the police looking in an area that was expressly protected by the Fourth Amendment, or was there protection under the expectation of privacy? And then, is it a search? Was there a warrant? If there was no warrant, do they have a valid exception? If yes, it's good. If no valid exception, then we fall to, is there a valid exception under the exclusionary rule? Now we have to go back and use our exclusionary rule flowchart. So remember, that's our last gasp. We're going to say that the evidence should be excluded, but we have a valid exception under the exclusionary rule. So when we use that analysis here, we start governmental action. Yes, there was governmental action. Police were involved, and that was Bordeaux. Is it expressly protected or meet expectation of privacy test? Yes, it was an apartment, which is a home, which is expressly protected under the Fourth Amendment. Was there a search? Yes, they went into the apartment. They pushed the door open and walked into the apartment. That was an illegal search. Plain view would not apply here because the police were not legally in the apartment at the time they walked in. They had no warrant to walk into the apartment. So is there a warrant? No, there was no warrant in this case. So now, was there a valid exception? So now we go through each of the exceptions we just learned to see if there was. Possibly emergency exigence, only if there was a real emergency where someone could have been hurt. In this case, they really had no reason to believe that there could be injury, so they did not have a valid exigent circumstances exception. Did any of the exceptions to the exclusionary rule apply? No. So our conclusion is, since they violated the Fourth Amendment and conducted an illegal search without a warrant, the evidence will be excluded at trial. Okay? So here's another one you can try to work through on your own. You can stop and see if you can work through it. I also posted some problems online. So if you wanted to go through the problems and make sure you understand this step, the problems are there. You can try them and then look at the answers and see how you do. And then when you feel comfortable with it, then you can complete Chapter 6 assignment. Okay, so that's it. That's all I have. That's the end of Chapter 6. So that's what we're going to do the rest of this week. Hopefully that makes sense. If you have any questions, please know you can always reach out to me. I'll always answer them. And otherwise, I will see you next week.